He commits two crimes, habitual felon. He gets arrested, puts himself out, and then goes right out and commits a murder.
Well, Your Honor, it's
Is that right?
alleged.
Is that right?
That's what he is alleged to have done. Yes.
Okay. The grand jury decided that he did that,
Understand.
and apparently the authorities. Okay. What's his bond?
At 1 million on the murder, 50,000 on the other two.
All right.
The
What
bond is
else?
still good on the other two.
Okay.
I'm sorry.
The bond is still good on the other two. They're still open bonds.
Okay. It's $1 million is the
What
main
else do
one
you
that
want to
we're
add?
concerned about.
What else do you want to add?
Well, Your Honor, we would ask that Mr. McCain, if the court were so kind to reduce his bond at all, from the current amount of $1 million to whatever it feels is reasonable, that he be ordered to wear a GPS tracking device, that there be some strict conditions setting the bond. There's been no evidence that he's not going to appear for future court dates.
What about the evidence that he might be a danger to the community?
So let me just address the evidence, Your Honor, in the murder case. So there is a lot of digital evidence involved in this case. It's going to take a lot of time to review. We may have to end up hiring our own forensic expert.
Okay, what's stopping you from doing that?
Well, Your Honor, it's becoming it's a challenge to prepare a defense with Mr. McCain in jail.
Your criminal history is rich, and it goes back to 1987. It looks like 2 convictions of illegal possession of controlled substances out of 252nd District Court in 1987. After that, those became final. Paragraph 3 goes on to state you committed another felony of illegal possession of controlled substance and was found guilty of that in 1990 in this court, criminal district court. After that was final, you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony in 2007, and were finally convicted of that. That was
It's still.
so you were a habitual criminal 2 convictions ago. So your bond is $250,000, and the circumstances here is that police on Friday, April 10th this year, were dispatched to Swift gas station 4705 Magnolia here in Beaumont, Jefferson County. Observed a black male laying on the sidewalk who had been shot. And the police reviewed the store surveillance camera showing you shoot him, and you were detained, and they found you in the area, and you were Mirandized and agreed to speak to officers and admitted to shooting Caesar. You were then placed under arrest for aggravated assault. And when they searched you, was that cocaine found on you?
That's what it appears like, Judge. I'm checking,
Yeah.
I don't see where we got.
And 2 firearms. You're a convicted felon already. As you know, you're unable to possess a firearm. It's not only a state crime, it's a federal crime as well. Man. All right. It's $250,000. The bond is go ahead.
If I may, this happened or occurred at his residence. There's a question of whether or not he can have a firearm or not with reference to the possession on the state side. I understand the federal side. The The instrument that was used, that he admitted to was a BB gun. Yes. And when they found the complainant on the, in front of the convenience store, he was too intoxicated or high to even communicate, so they brought him to the hospital at that time. This had to do with an incident that
You said the defendant. You're talking to the victim.
the victim
Oh, I thought you said the
was
defendant.
already done. The victim was out in front of, was in front of the convenience store. You know, it was a termination that he was too intoxicated or high at the time. I questioned the indictment, you know, if it's to a firearm. I don't believe a BB gun constitutes a firearm, though a BB gun could be a deadly weapon. It's not alleged that way. I'd ask that that the bond be lowered. One, because it was on the house. There was a complication between the complainant and Mr. Goodman. And he would not leave and he was threatening him. And I know those are matters for trial. But we would ask that the bond be reasonable in light of these circumstances. And I believe possibly the controlled substances were when they went inside the house and not on his person.
Anything else? From you, Stacey?
Oh, Judge, I think we've got a good grasp, but I would tell you that the reports don't state a BB gun. They do mention the pellet rifle. But the state feels that the specifically based upon his admissions and his criminal record that the county can only be safe if the bond continues at the amount that it's set.
Yeah.
Well, yeah, you're right. He's sitting on his front porch in his own house minding his own business. That's where it occurred. It didn't occur in the parking lot of
That's just not what the probable cause affidavit states.
But that's where he was.
The bond, the court feels that this bond is appropriate under these circumstances in your rich criminal history.
We'd
That
ask
is
it
all.
in place on the trial.
It's going to be set for trial. Okay.
Mhm.
All right. Let's see. I've got is Tom Kelly here? Darren Peace? Tom Kelly, Darren Peace?
Tom said somebody was standing here for him today.
Ben Jeffries is about signing him up, Judge, that's gonna be a plea.
Lori Perozzo, you ready on Jamal McCain? What are we going to do?
A bond hearing.
Come on out. For what? For whom? Jamal McCain?
Yes.
Need Jamal McCain, please. Thank you.
I think it's in another stack, Judge. I've got two other ones here. All right, here.
Three.
Yeah.
You good? Think so?
So do you think, Chief?
Yeah, I'm good. I think I'm good. Did I get a notice? I gotta go look. I don't remember getting a notice, but that's okay.
You did the defaults, who went over them.
All right. Is this, you are Jamal McCain?
Yes, sir.
Okay. You were here with Ms. Barroso, your attorney and the state's attorney.
Yes, sir.
You're charged with 3 habitual felony crimes.
Yes, correct.
So you're looking at 3 times 25 years to life imprisonment, 3 times that. In 23 CR 795, third-degree felony of tampering or fabricating with evidence. You have 3 prior convictions in sequence. controlled substance, and evading arrest or detention with a motor vehicle. So you're looking at 25 to life on that. Unlawful possession of a firearm by a felon on April 18th of 2023, the same date as this earlier one. And the allegations are similar with the prior convictions. You're an habitual felon on that one. What's the date he was arrested on these two? Anybody know?
I'm not sure, but I do know that he's been incarcerated for 3 years as of June, sometime first week of June, or fifth.
Well, how long have you been representing?
Well, I was appointed in February. I'm his third attorney. His last attorney was Ryan Matuska, who we all understand has gone over to the federal.
I didn't know
defenders.
that.
Oh, I thought you were aware of that. Sorry.
No,
So he.
don't necessarily tell me.
Previous attorneys that withdrew. I'm his third, I'm his second appointed attorney. I believe the first one was hired, which was Marcus Wilkerson. He ended up withdrawing. Mr. Matuska was appointed. He ended up withdrawing, and then I was appointed. And from my understanding, this is the first time that Mr. McCain has been before the court on asking for a bond reduction. And he's been there for over 3 years.
He was arrested June 22nd, 2023.
Often state was, I think, around the first part of June.
All right. So he's charged with those two. Then thereafter, before he was arrested, a couple months later, he's charged with a
It was
murder.
a couple weeks.
This says April 18th.
I stand corrected.
April 18th and then June 6th, which would be April, May, June. So I'm thinking about 6 weeks or 7 weeks later, he's accused of committing a murder. And in each of these three cases, he's classified as an habitual felon. He's finally arrested on
June 22nd.
He said that was for the murder. He was arrested June.
June 22nd. We're finally arrested on something
Well,
on June 22nd of that year.
May 21st of 2023 on the tampering and the unlawful possession, and he bonded out on May 24th of 2023. And then he was
That is,
arrested.
you know what? Okay, I was curious about that because that's not in here anywhere in any of this. I swear, it's not. I don't have a 23. So
And I believe that he is entitled to a reasonable bond. He's innocent until proven guilty,
unless proven guilty.
unless proven guilty. But this offense is an alleged offense. He hasn't been convicted. He's been in jail for 3 years, and this is his first time appearing in court on a motion for a bond reduction. So I would.
That's
ask the
terrible.
court to take
That's
that
a long delay.
consideration.
That's shameful, I
Yes,
think.
sir.
I don't know what happened on this, but I'm glad you're in the ball game because you move things along.
Thank you.
State.
Yeah, we
Anything?
think the bond is sufficient due to the fact he was out on a felony, commits another felony. And we do have a little bit more than what she's saying as far as evidence is concerned. I have.
The court finds that the bond is reasonable under these circumstances. These are extraordinarily serious, severe circumstances. He was arrested, charged with serious criminal felonies, and then thereafter is released on bond and commits murder in a few weeks. And the court finds this bond to be reasonable under these circumstances. We'll set it for trial.
Yes, sir.
Okay. Try to fast track this, please.
Yes, sir.
I'm not asking you, I'm asking her.
I think we're set for trial in September.
Yeah.
already.
Okay, okay.
We probably already have.
Should
trial
put
dates.
that, I'd like that to be prioritized as number one. Mr. Laird, if you're going to be handling that, it's set for September.
Yes, sir.
That murder case, let's try that first. Thank you.
Okay.
And he's got a third case too, doesn't he?
Well, there's,
Did I give you all three?
yes, you did, Judge. Yes, sir.
Aaron Simpson? Aaron Simpson is called. There is no answer in the courtroom. I asked the bailiff to call into the hall for Eric Simpson. Maybe this is a bond hearing. Scott Rennick is not here. His attorney? What's his bond? Something long overdue that had to be said.
Oh, you know what? It does say a festival, yeah.
Okay.
There's no response.
Who's Scott? Brent Turk? Hey, on Sarah Bado?
Yes, sir. Oh,
I'm calling it. It's,
I'm busy working, Judge.
You think that's the year?
I'm trying to get things done.
you know, maybe before the docket would be a good time to do.
I
these
did,
things,
Judge,
Maybe,
you know-
like the last 3 weeks.
We want to deal with it.
What are we doing?
We're pleading.
On Sarah Bado, you ready? Papers ready?
I'm ready.
You want which on?
On Sarah,
Is it a plea?
Yeah.
do you have anything in there?
Ms. Berwick, Ms. Bado, Mr. Weston, are all pleadings. I sent it to the prosecutor. The problem is.
Okay, hold on. I have Bado. I have Berwick.
Yep. And Mr. Weston's on there. He's got 2 cases, both of them are pleading.
All right.
Weston on here. Berwick.
What about DeMarcus Meyer?
We're gonna have to bring him out and talk to him a little bit.
What about, he's got 2 cases.
Yes, sir.
What about Reginald Robinson?
Mrs. Moore, they're looking at him for a possible plea.
Who are you?
Ms. Bado,
Bado. You know what? You've got the rest of those files on there.
Oh, hold on.
Bado is gonna be somewhere in there.
There you go. Shadow. I just need her paperwork.
22-39916 is called Sarah Marie Bado. That's you? Present, ma'am? Yes.
Yes.
And you're here with Mr. Turk, your attorney, and the state's attorney. There's a first amended motion to revoke probation filed here as of February 14th of a year ago. Does the defendant waive a formal reading of this? Can we proceed in summary?
yes, Judge.
Raise your right hand, man. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this states in this motion that on June 26, 2023, in this court, you were sentenced to 2 years in the state jail, probated for 53 months. And I guess you had served some time already and we were giving you credit, I guess, for that. And that was for the state jail felony of theft. Is all of this true and correct?
Yes.
What's she pleading to?
1 and 2, Judge.
Looking at what was up the top. How about first amended 5? That's failing to report on those months, July, August, September, October, November, December of 2020. Is that good?
That's fine, Judge.
All right, number 5 here, first amended 5 states you failed to report to the Jefferson County Probation Office as required for the months of July, August, September, October, November, and December of 2024. That is a violation of condition 4 of your probation order, which states report as directed to the probation office and obey all rules and regulations of it. Is that allegation true and correct?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked for this state jail felony, and you can be sentenced no less than 180 days up to 2 years in state jail. Knowing that, do you insist on pleading true to that?
Yes, sir.
Find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. Agreement's been reached. You would be pleading true sentence to 24 months. Can we just put 2 years?
Yes, sir.
Okay. I don't want somebody to say 24 years as it processes its way through the system.
Yeah.
That would really,
Don't agree to that.
2 years in the state jail, is that your understanding of the agreement? I'm gonna change to,
Yes, sir.
change pleading to counts 5, okay?
I'm saying this.
Send something back there to you.
You'll be waiting.
Even Don's, yeah, notice. It's 3 years to, it's 3 years to go. It's fascinating.
If I follow this agreement, ma'am, you have no right of appeal. Do you understand?
Yes, sir.
Let me show you what's marked here. States Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney or the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection. Admitted. This states, among other things, if I follow this agreement, I'm going to do this. You have no right of appeal. States Exhibit 1, part of the record for all purposes, pre-sentence reports waived.
Yes, Judge.
I'm going to find, if nothing further, that you have pleaded true to allegation 5 of this first amended motion to revoke probation on cause number 22-39916. You have done this voluntarily, knowingly, intelligently. And upon discussions with your attorney, that is enough to find this allegation true and correct by a preponderance of the evidence or greater. I so find. And your first amended motion to revoke probation is hereby, this motion is granted and your probation is hereby revoked. You are hereby sentenced to confinement in the state jail division of the Texas Department of Criminal Justice to serve a term of 2 years. Do you understand what has happened today, ma'am? Anything else, Brandon? That is all. Thank you. Berwick? Elizabeth, Charlize? Did you sign everything already? Go to that lady, thanks.
This is Ms. Barwick. Yes, thank
It's in a therapy. Oh, then I don't need a printer. Yeah.
I need a file. I think you've got a file in there somewhere. We're getting toward the back of this.
Yeah, there you go.
Over. Yep.
25 CR 313 is called, is it Charlize
Yes, sir.
Berwick? There's a first amended motion to revoke unadjudicated probation that's been filed here, ma'am. And you will hear with Mr. Kirk, your attorney and the state's attorney. The probation officer's officer here representing the state. And have you had a chance to discuss this? You understand the situation you're in here?
Yes, sir.
Oh, no. What are we going to do? What is she going to be pleading
I
to?
think it's 2 and 3 judge.
You do think?
Well, it's been a minute since I did it, but I think it's 2.
We're showing. All right, there is a first amended motion to revoke unadjudicated probation filed in this. Please raise your right hand. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, man?
Yes, sir.
Oh, lower your hand. In summary, this first amended motion states that on June 17th of a year ago, 2025, in this court, that you were placed on 2 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is that true?
Yes, sir.
Allegation number 2 states that you committed. Stand by. That you violated your terms of probation in that you admitted to using tetrahydrocannabinol marijuana on or about August 9th, 2025 in violation of condition 10 of your deferred or unadjudicated probation order, which states do not use or possess any drug. Is that true and correct?
Yes, sir. What's number 3?
Just the same thing, but
Well, we're not going to waste time on just beating it twice. Are there any other violations we need to do?
one's enough.
That's one's enough. The other one states you admitted to using illegal drugs, namely marijuana, on that date, and you have essentially pleaded to that condition 10 already. So we're not going to. Your time's valuable in all of our issues. But you understand that a voluntarily and truthfully made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced up to 2 years in this case in the state jail. So knowing that, do you insist on pleading true to this?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading guilty. And agreements by the parties been reached, your probation would be revoked. You would be sentenced to 15 months in the state jail.
Yes, sir.
You would be given time for all credit for all time you have served in accordance with this case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of the case. Do you understand?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Would you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered.
No objection.
Without objection admitted. This states, if I follow this agreement, you have no right of appeal. I'm going to follow this agreement. All right. If nothing further, I'm going to find that you have pleaded true voluntarily, knowingly, intelligently to allegation 2 of this first amended motion to revoke unadjudicated probation in this cause number 25 CR 313. That is enough to grant a voluntarily and knowingly made plea of true to one or more violations of probation, which is in this case a violation of condition 10 of your probation order. You were required to abstain from the use of illegal drugs. That is enough to grant this motion to revoke probation. The motion is hereby found true and granted by a preponderance of the evidence or greater. Your probation is hereby revoked, and you were hereby sentenced in accordance with this agreement to confinement in the state jail for 15 months. Do you understand what has happened today, ma'am?
Yes.
Anything else to add, by any chance? That is all. Good luck. Yes, ma'am. You're going to be given credit for all time you have served, ma'am, in accordance with this case. You're going to go on DeMarcus Meyer.
I think we need to bring him out,
DeMarcus Meyer, please.
talk to him because it's not something.
They have Weston too, right?
Mr. Meyer
And Reginald Robbins.
Mr. Robinson's being with the Myers mental health. Mr. Meyer has been off for mental health.
Okay, is he still gone?
He's still here.
So what are we doing today?
He's coming out to say his piece. Yeah,
Who?
say his piece.
No, I'm talking about Reginald Robinson,
They were looking over for, sorry, Judge.
but he was sent off.
No, Meyer was.
Okay.
Meyer had been sent off. He's back.
Oh, he's back.
And so is Mr. Weston. Mr. Weston's going to plead.
I need Meyer and Weston. There's two cases on DeMarcus.
And so Mr. Robinson, they just.
Yeah. Who is this?
This will be Mr. Meyer. Mr. Robinson will be
And here's-
later.
Weston.
Okay, here's Weston. You're DeMarcus Meyer? All right. Myers. Correct me if I'm wrong, but he's on probation in these two cases, 18-30326 and 23-4765, correct? What are we doing? They're thick.
Yes, sir.
He's been around a long time. What's he doing? He's just languishing. What are we gonna do?
The state made an offer of 3 years and Mr. Meyer said we did not.
Oh, okay. Then the only other thing is to have a hearing.
Yes, sir.
Okay, when do y'all want to do that?
Couple of weeks, Judge, it's fine.
All right, in 2 weeks, we will set a hearing on these two and dispose of them. Okay, it'll be that, and there is no deal. There is no deal. We're gonna go.
Where I'm still be sent in jail.
Yeah, you got
Still
your.
to living condition though.
Bye.
I haven't been booked in the process. It's not.
There are no deals after today. We're just, I'll be the one making the decision. Thank you. Here's DeMarcus Myers stuff. Who is next? You said Weston? William Weston?
Yes, sir. That's going to be it. And then Mr. Robbins is going to be, we have to do the paperwork when we're done with this.
Weston.
He's good. Mr. Weston has two.
You have Weston.
I gave it to you, Judge.
You did?
I did.
I had two cases.
That's it.
Weston's.
Printed. Printed.
Yes, this is actually going to. Little window right there.
All right, while we're doing that, we're going to call two cases, 24-1785 and 1787. These are two indictments styled the state of Texas versus William Weston. Mr. Weston is charged with assault on a public servant in each of these cases. These are third-degree felonies. These look like were committed on the same day. And looks like two different victims.
Yes, sir.
Correct?
Yes, Judge.
All right.
Judge.
Mr. Weston.
Are the same deals being made on both cases?
Yes, Judge. One concurrent, 10/10.
And you are William Weston,
Yes,
here, with Mr. Kirk, your attorney and the state's attorney. You were charged in these two cases, 24 CR 1785 and 1787 with assault on a public servant. These are third degree felonies. Do you understand, sir?
Yes.
All right. Earlier, the defendant was deemed incompetent to stand trial. And based upon findings from Dr. Ed Rupon. And on June 15th, the University of Texas Health Services Center at the John Dunn Behavioral Sciences Center sent us a statement that the defendant has achieved competency and to send him back to Jefferson County to dispose of his cases. And that's what we are doing here. The court will note in the record that on June 15th, 2026, the University of Texas Health Sciences Center on this defendant's behalf for these two cases stated that the patient has been evaluated and is now competent to stand trial. Therefore, pursuant to Article 46B.076 of the Texas Code of Criminal Procedure, the court shall issue a bench warrant, which is what we did, to pick up the patient, transport him to court. And that's where we are. So those documents are all made a part of the record. And we will take these cases up collectively, okay? If that's okay. In each of these cases, 24 CR 1785, and the defendant waives formal readings of these, we can proceed in summary. Just in each of these cases, sir, Mr. Weston, it is alleged that on or about August 9th, 2024, in Jefferson County, Texas, you committed the third degree felonies of assault on a public servant, two different public servant officials who were apparently, one was a security guard in lawful discharge of securing you where you were at the emergency detention facility and pending an emergency detention order. And the other public servant was a registered nurse who was attempting to medically evaluate you. Each of these are third degree felonies, which means you face no less than 2, no more than 10 years confinement in prison and a fine up to $10,000 in each of these cases. Do you understand what you are charged with and the punishment ranges applicable, sir?
Yes.
Agreements have been reached in each of these cases where you would be pleading guilty and would be sentenced to 10 years in prison. And after that, you would be placed on regular probation for 10 years. And each of these sentences would run concurrently. Is that your understanding of the plan? If I follow this agreement in each of these two cases, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these two cases to these third degree felonies of assault on a public servant? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your free will and because you are guilty.
Yes.
I show you what's marked as State's Exhibit 1 in each of these cases. Did you sign those documents, understand them, discuss them with your attorney? Are the contents true and correct?
You signed it?
Or are those true and correct?
Yes, sir.
State's Exhibit 1 in each of these cases is tendered
Objection.
without objection admitted. This states that you are mentally competent to enter your guilty plea. In each of these cases, these are freely and voluntarily made. You know what you've been charged with. These documents have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided. Hold on, the computer stopped. provided by your attorney. And all of this is true. It states, so help you God. States Exhibit 1. This is part of the record in each of these cases. Pre-sentence reports are away.
Yes, sir.
In each of these cases, I'm going to ensure that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You understand and appreciate the consequences of them. There's sufficient evidence supporting your guilty plea from States Exhibit 1 in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felonies of assault on a public servant in each case. I am following these agreements. You are hereby sentenced in each of these cases to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 10 years. Those sentences shall be suspended, and you are placed on regular probation for 10 years on each of these cases. These will run concurrently. There will be terms and conditions of probation, which are normal and customary for each of these cases. Make sure you follow them. If you fail, your probation can be revoked. You can then be sentenced up to 10 years in each of these cases. You don't. Where are you going to live? You're transient, but do you have a plan?
Yes, sir.
Where?
I go to church, I need some help on my church.
Here, the area?
Yes, sir.
Okay, good. Well, where's your family?
Alberton.
Okay, they're really close, Ron. Do you still communicate with?
Yes, sir. I do.
Oh, that's family's important. Okay, do you understand what's happened?
Yes, sir.
Okay, good luck to you, sir.
I'm gonna go side with sticks and things.
That's not my house.
You should tell them. You say everything, but I was there. So I'll take you to this case. You get a shot, right? I well, the Virginia and. Yeah.
You are not a good dog. The computer is giving me trouble there.
Yes, was somebody.
Go out quickly and it's.
No, that's perfectly fine.
All right. Mr. Weston, good luck to you there, buddy. Good luck, sir. Thank you for going.
Let's see.
Where are you going? All right, for Brand. I was looking for Brand. Brett.
He's very
Brett, come on out. You still have just a couple more, I think. Reginald Robinson.
I'm doing the paperwork now.
Okay, is that it
That's it.
for you? Okay, a little star for you. You deserve stars. For some reason. Christopher Baker. Where's Christopher Baker? Come on up, sir. And where's Oscar Lewis? Is Oscar Lewis here? That's gonna be the file.
Yes.
Right, you're Mr. Baker.
Yes, sir.
In 26 CR 955, you were charged with obstruction of retaliation of third degree felony,
Yeah.
which occurred according to this indictment on or about April 4th, 2026. And this carries with it no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 to be assessed. Are you getting a lawyer?
Yeah.
It's important you get one.
Yes, sir.
You don't want to do 10 years in prison.
Yes,
So they can come in handy.
Yeah.
I'm going to give you some time to go find one, okay? 4 weeks. And come on back and tell me where you are on, are you employed somewhere?
Yes, sir.
What do you do?
GCS Industrials.
How much do you make an hour?
19, 18, 18.
Okay, that's about 40 grand. All right. Well, when you go talk to them, make sure they understand what you're charged with here, okay? So they know how to deal with this.
Yeah.
I don't see any prior convictions here. You don't have any, do you? Okay, well, you don't want one.
Yes, sir.
That'll break a lot of opportunities off.
Yes, sir.
All right. Get a resetting, see in 4 weeks. Oscar Lewis. Is Oscar Lewis in the back? Kendall?
I don't show him in person. Yeah, I can check it.
Oscar Lewis is called. There is no answer in the courtroom in 25 CR 1191. I asked the bailiff to call into the hall for the last time for Oscar Lewis. Hard for me to say that. Dennis calling for the last time.
I know.
No response to that name called into the courtroom. No response to the name called into the hall. A warrant shall be issued for the arrest of the defendant, and his bond is this is a forgery
I'm right here.
of $25,000. The defendant's conviction, 2 prior convictions of credit or debit card abuse, and now he's charged with forgery.
25,000.
Okay, the bond is revoked. The warrant shall be issued for his arrest. Bond in the amount of $50,000 is ordered. And the defendant shall be required to have a GPS device, remain on home confinement, and will be allowed to and from his home in the most direct route possible for the exceptions the court always gives, and that's to work, to attorney, to court, to get food. Is Paulette Powell here? Paulette Powell? Ryan Gertz was supposed to be. I don't see Ryan. I don't see Thomas Kelly either.
I'm here for Tom. But not for.
Where's he today? Listen,
Oh, no.
that's it doesn't really matter. I guess. All right. While we're looking, what about Pauletta Powell? Pauletta Powell is called in the hallway. No answer. I asked the bailiff to call into the hall for Pauletta Powell. This was supposed to be a plea. There are 2 cases.
Let's see if I have it.
Maybe not. No, I haven't. All I have, you can touch.
There's no response, Connor.
Oh, you should both clear it.
29. Yep, 629.
Which probably no. He doesn't know that Gene had this, so he starts a song.
I've talked to him.
Is he in custody?
I think this one was one of the ones we moved from the afternoon to this morning. I did inform everyone, but
Just show both cases. That's not very. This
That's the one I did Friday, because it was originally said at 1:30 today. Moved everything up to this morning, so I just redid what it said. So. We originally on Tuesday, but they said everything on Monday. And I did text him. And I even left us on this too, but then we redid it again, the 18th, which is when it's on Monday, so we moved it. The 18th, we moved it to today, this afternoon, and Friday, it from the afternoon up to the morning. That's all. Let me text him and see if he responds.
Okay, we're gonna try to get with Mr. Gertz because there's some docketing movement that went on in both cases. And it looks like the last decision was, it was moved from this afternoon to this morning. And that's odd, he's not here. Tom Kelly, Darren Peace. One Darren. Darren Peace. That's yours?
Yes, John.
Okay, Darren. Peace.
Let's see. Just one test, two. Let me go get it. One maybe not having two
What are we doing?
files.
Please.
So
it's the same case, Judge. It just got split up into two separate files. So
Say that again?
there's three ones in the same case.
Which one? There are two 24 CR 1632 files I'm looking at, two separate files. Second degree felonies of assault on a peace officer. Somehow the state has figured out a way to make more numbers by using the same event.
I only have one, Judge.
This is,
We only are leading tools.
it's weird. Hey, Lance, what do we do with this?
Huh?
I got two duplicates. What do I do?
These have two separate files, the one don't want. It's just one file.
So which one do I use?
Either one, doesn't matter.
What do I do with the other ones?
We'll fix it.
We'll fix it. We'll combine them, Judge. It's right off.
Do you know how expensive files are?
See how we did it? We took care of that.
We don't throw this.
Well, that's, you don't have a problem with that, do you? No, I don't know why that is. That's all we need is duplication. 24 CR 1632 is called Darren Peace. Mr. Kelly is your turn. Correct. Now,
Put out fires.
I know. I know.
All fair space.
I'm seeing the photos of it. I'll let you. Not that yet. This is stupid.
Yes, God, started. I mean, we're trying to switch.
I smell smoke.
No. Well, we put it out. Put out one.
Okay, Mr. Peace, you are here with your attorney. Mr. Kelly is your attorney, but Mr. Jeffries is here in lieu of that.
Yes, sir.
He works with him on cases and do you have any objection to him standing in?
No, sir.
Okay. Does the defendant in this case who charged with the second-degree felony of assault on a peace officer waive a formal reading of the indictment and arraignment? Can we proceed in summers?
Yes, Your Honor.
In summary, this indictment alleges that on or about July 7th, 2024 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you are charged with here, sir?
Yes, sir.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
It worries. My staff's behind me. We're working together, talking. I got a wife and children at home. Yeah, I get worried about that when they start pulling that. Figure out. You're
There's, I don't even this one's the you know, it's fake.
An agreement has been reached, sir, in your case here, you were looking at, if convicted, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. And an agreement has been reached that you would be pleading guilty and not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Do you understand that to be the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will, because you are guilty.
Yes, sir.
Let me show you what's marked as States Exhibit 1 here. Did you sign that document? Understand it? Discuss it with your attorney, or the contents all true and correct? States Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, to state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been given to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived here.
Yes, Your Honor.
I'm going to follow this agreement with nothing further. I'm going to find you are pleading guilty voluntarily. If you are mentally competent to do so, you understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea to find you guilty beyond reasonable doubt in this case. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation. There will be terms and conditions of probation which are normal and customary for this type of offense. Stand by. You will be placed on probation here for 10 years. You do well, it can be shortened to 1/3 of that. Do you understand?
Yes.
There was a, you just can't strike your police officers like that in the face when they're doing their job. Among the other terms and conditions of probation, there will be anger management, which is probably a good thing for a lot of people. It'll help you controlling your emotions when there are important decisions that have to be made. Anything else? Please see the probation officer. That is all. Thank you.
This piece, see you. This go out this. I'm so glad.
Here's that. Richard Cook. I have Richard Cook.
That's a three judge already. No.
You see that lady first. She's gonna.
Okay. I leave it. I possibly that's not the leader. The same time that is
The physical treatment for 75. If you're right in front. Place it flat right there on the wall.
with the list.
Think back and look up. Place it flat right there about. There you go. We'll see you after that.
If there is, yes, if there's someone who's.
Okay.
You are Richard Daniel Cook?
Yes.
Okay. Does the defendant who's here with his attorney, Mr. Galmore, waive a formal reading of the indictment and arraignment? Can we proceed in summary?
He doesn't do that.
In summary, this indictment alleges that on or about September 18th, 2021 in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you're charged with, sir?
Yes, sir.
If convicted, you face confinement in a state jail for a term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty. Placed on deferred or unadjudicated probation. And restitution is owed. Is this 14 or 4?
That's my handwriting and it's 4,000. It's the tablet, Judge. I'm gonna stick with that story.
It's a good mechanic who blames his tools.
Good thing I'm a bad mechanic.
Wait, when is that going to be? When can that get paid back? That's what I'm always anxious in knowing for victims. Quickly, by the way, the quicker you pay it back, all things being the same, the quicker this baby ends.
That just
Because our
started,
reward.
I apologize. This started at $10,000 restitution. He paid 6,000 last month.
Okay.
And so
We had the rest 3 weeks ago, but 4 months.
When are you going to be able to pay the rest of you back? In 4 months?
Yes, sir.
That's a promise?
Yes.
You will be rewarded.
Absolutely.
it's part of the reason why we have the deferred probation set up as a short period so that if he accomplishes that.
What is the period of time?
3 years is.
That's not what it says. It says 3 months, years.
That's true. It does say 3 months here. We'll go with months.
It's intended to be 3 years, Judge.
We might need to change the 4
Is
months.
that your final answer?
Yes, sir.
All right. And it's a non-binding recommendation. I will follow this. It will be 12 years. And it can be shortened from that.
Okay.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
How do you plead to the state jail felony? Guilty or not guilty?
You give.
You and your attorney have just pleaded guilty. Both.
It's a
Something
good,
long overdue for Dustin, by the way.
it's a good day, Judge.
I'm still waiting to why. When he fesses up finally, that'll be, we'll all have a holiday. Okay, are you pleading guilty seriously, voluntarily, and because you want to?
Yeah.
And you have, you're heeding the advice of your attorney.
I said. He said,
If I follow this agreement again, you have no right of appeal. I'll show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney, or the contents cleared correct? State's Exhibit 1 tendered into evidence
it's not official.
without objection. This states you are mentally competent to enter your guilty pleas freely and voluntarily. As you know what you've been charged with, you read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true. It states, so help you God.
Yes.
State's Exhibit 1 is made a part of the record without objection. All right, pre-sentence report's waived. And I'm going to follow this agreement. If nothing further, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilty so long as you follow these terms and conditions of probation.
Yes, sir.
This will be for 3 years or short. It will be terms and conditions of probation. Normally customary for this type of offense, which include theft prevention class. There are 35 conditions of probation. Most of those I have to follow and he has to follow. You know, it's like don't commit a crime and work faithfully, you know, the kind of thing that, so people go 39, my God, I got a life. This is part of your life. It's just continue to do what you're doing well.
Yeah.
And fix what you have made a mistake in. And also restitution is ordered in the amount of $4,000 and you know who to pay that to through probation. And once again, I want probation to let me know when that happens. So the reward will be passed on to you as I pass. Anything else? Please see the probation officer.
Thank you. Your Honor, I have one additional case. But he's not here. And I believe he was originally scheduled to be here at 1:30. I haven't been able to look at him on the phone. I do expect it to be a plea. And so if the court would consider moving to Monday next week, I'll make sure he's here and we can do the plea.
Who is it?
It's John Landry. So, the offer is brilliant. He's supposed to be here at 1:30 today.
That's a deal, right? We'll set that for a plea on Monday. Is that okay?
Next week,
Oh, the sixth?
the 6th.
Okay.
Yes. Just in time.
It's not me, it's all that.
So consider research. Supposed to.
Yes, down, fall in. Does Langston ever show up? We'll never see him again. I bet. On Ryan Gertz, did he ever, he thought he'd saunter in and then leave?
No,
Pauletta Powell?
Councilman said that he was in Orange County this morning.
What'd you say?
He had, He hasn't replied to my text, but
Want to hear something else?
Here, just, there you go.
well, then I don't.
Nice, who's out here?
What about Ryan Gertz?
Yeah.
You're not Ryan Gertz.
Oh, my bad. I thought you said me call.
No, where's Ryan Gertz?
I just saw him outside not too long ago.
What's going on out there?
Huh?
You want me?
Yeah, I just,
I need to go out there and,
I know, I saw him on.
Hey, Court?
On us.
all right.
He had a hat on.
What do we do? Okay,
I got
Thanks.
I have three for you. That's sent.
right now, you ready?
Ready on three, already sent.
Okie dokie. Crystal Biscamp?
She's on the initial. Judge, I just want to move her to the announcement. And I'll finish doing the.
Where's Crystal?
Is she right here?
Yeah, we're gonna place this on, hold on, Crystal. Flagpole here. In 26 CR 957, you were charged with operating a motor vehicle in a public place while intoxicated with 2 or more prior convictions. Fix that. You gonna fix that?
Yes, sir.
You're looking at up to 10 years in prison. For these kinds of for these kinds of cases, these are convictions on DWIs. They're real hard. The legislature made these hard. That's why don't operate a motor vehicle while intoxicated. You just can't get deferred or unadjudicated probation, which keeps your record clean on this kind of thing. He's working with this. You want to move this at another time?
Yes, sir.
How long?
4 weeks maybe.
How about 5 weeks?
Perfect.
All right, we'll reset that 5 weeks. Also, you have an interlock device in any vehicle you operate? Okay, that's important. If you get caught without one, you go to jail. All right, don't do that. All right, please get a resetting from that lady. Thank you.
Thank you.
Miranda Boland.
Send it to you. You too. That's the.
Miranda, there she is. Yeah, she's been. She's not that quiet. All right, we now call 25 CR 554, the state of Texas versus Miranda Boland. Is that you, ma'am? And you're here with your attorney, Mr. Adams, and the state's attorney does the defendant. We have a formal reading of the indictment and arraignment here. Can we proceed in summary? Yes.
Yes.
I'm making it. In summary, Miranda, this she's on a motion to revoke probation, right?
Yes, sir. And she's,
You were earlier indicted for criminal mischief, and you were placed on 5 years deferred or unadjudicated probation for that after you pleaded guilty back in November. And I'm disappointed because I wanted to see you successful on this. And does she waive this formal motion to revoke unadjudicated probation? Can we proceed in summary?
yes, sir.
Please raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke probation. Looking for the date it was filed. I don't have a date on this for some reason. That's odd.
The date the motion was filed?
Yes, ma'am.
It should be March 5th of 2026.
Yes, it's not stamped on this one. Nonetheless, it was filed on March 12th, 2026, according to the file. Yeah, see, I don't got one with nothing.
Yes, sir.
For some reason. We need a copy of this for our file, though.
Just it may be in the computer.
In summary, this motion states that on November 17th of 2025, last year in this court, you were placed on 5 years deferred or unadjudicated probation for criminal mischief. Is all of that true? A state jail felony? Yes. Okay. Allegation, what's she pleading to?
The first one, which is one felony case.
One.
One.
Allegation 1 states you committed the offense of assault causing bodily injury to another on or about December 18th of 2025 in Orange County, which is a violation of condition 1 of your probation order, which states do not commit an offense. Is that allegation true? Or yes? Are you pleading true voluntarily and because it is true after discussions with your attorney? Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
So good. Yes. You want to plead true to dates, move forward? Yes.
Yes.
An agreement has been reached where your probation would be revoked. You would be found guilty and sentenced to 1 year in the state jail. Is that your understanding of the agreement? How much time does she have credit for? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yeah.
Also, there's a case in Orange County, isn't there, for assault?
That's correct, Judge.
Is this? And that's what allegation one is here.
That's correct.
Out of Orange County. All right. I intend to follow this agreement. If I do, you have no right of appeal of your case. Do you understand?
Yeah.
Anything else to add by anybody? If not, I'm going to find as follows that Miranda Boland, you have pleaded true to allegation one of this motion to revoke unadjudicated probation voluntarily, knowingly, intelligently. That is committing the offense of assault causing bodily injury to another on or about December 18th, 2025 in Orange County. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation can now be revoked and you can be found guilty. I grant this motion. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, which was just a month before you committed this offense, you were placed on probation, violent, by this court. You had pleaded guilty to this underlying criminal mischief case, a state jail felony, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea at that time during your plea hearing to find you guilty beyond a reasonable doubt. Even though we deferred any finding of guilt, that deferred or unadjudicated order of probation is hereby revoked. You are now found guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for a term of 1 year.
Just 281 days credit.
All right. You've got over 9 months credit. So they're going to take you in and you're going to have to complete the remainder of about 3 months. Do you understand, man? And then you will be released. What are you going to do when you get out? You have a plan? Who are you going to live with? Nobody. You're not, are you homeless? Oh, okay. Where's your family?
No, they're
You don't know where they are?
No.
Nobody? Nobody in the family? You know what? Where were you born? You don't know? But what's your date of birth?
September.
How do you know that? No, how do you know that? If you don't know anything about your family or anything. Okay. All right. That's a sad deal. Well, You gonna do better? Promise? Okay. Best wishes to you, man. Okay, that is all. Okay, who's next?
I think on the docket is Terrell Hopkins.
We took care of Darren Peace, didn't we?
Yes.
All right, on yours. Langston, let's see. I've got Terrell Hopkins. Are we doing something?
You know, he said, can I put on?
Well, I mean, we'll just do a motion to revoke hearing, right?
That's fine.
Are you ready for that today?
Not today. I wouldn't. Just
In 2 weeks?
2 weeks, perfect. We can
All
do
right, Terrell Hopkins, reset in 2 weeks for a hearing on the motion to revoke probation. He wants something. All right. He's looking at 10 years, right?
Yes, sir. I believe
Okay.
the offer was 6, if I'm not mistaken.
Well, okay. Cameron Kroger.
I sent that to you.
Okay. Need Cameron Kroger, please.
That's the.
That's Then we have Earl Clancy, 2 cases. What are we going to do on Earl?
Earl Quincy, he was another no, so that's it. I'm hearing you put it on the same date that you do the Hopkins on. If you
Okay, Earl Quincy's 2 cases.
Same day.
We'll reset that in 2 weeks.
If you don't mind.
We'll deal with the motion to revoke probation first, okay, everybody?
That's fine.
State, you understand? Earl Quincy reset for 2 weeks.
Yes,
On the
ma'am.
motion to
Yes,
revoke
sir.
probation, here's this place. Thanks. And what are we gonna do on James Robertson?
I sent that one.
That's in there too.
Mhm. You got that one.
And then Bryant Williams is the last one.
No. Brian Williams. Was it?
Is there an announcement?
Sorry. You sure I got Brian? Oh,
Yeah. Bryant Williams, Robert.
Mike's doing somewhere up bringing down, that is right now.
Okay. Thank you. If you don't,
We move everything up to the morning.
my bad. I didn't see that. That's on
That's
me.
okay.
If on Williams, if you wouldn't mind, may I just please have one reset on him?
All right. No, we're gonna do 2 weeks like the others.
That's cool.
Okay,
That'll be fine.
okay. Did you say Robertson?
Yes, sir. I sent the paperwork to you on Robertson.
Okay, I'm talking about Bryant Williams.
Oh, Williamson, that's 2 weeks.
Okay, we're gonna do 2 weeks on the Bryant Williams. And here at Bryant Williams. Okay. And you or James Robertson? No, you're Cameron.
Colger. I believe I'm saying that right. Colger. Mr. Colger.
23-39396, the state of Texas versus Cameron Gerald Koger. That is you, sir?
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of the second amended motion to revoke probation in this case? Can we proceed in summary?
Yes, sir.
Sir, raise your right hand. Do you solemnly swear or affirm Any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your heads. In summary, this motion states that on June 13th, 2022, in this court, you were sentenced to 10 years in prison and that was suspended. You were placed on regular probation for 10 years for evading arrest or detention with a motor vehicle, a third-degree felony. Is all of that true and correct, sir?
Yes, sir.
What is he pleading to?
Your Honor,
Well, you got some, there's 17 violations.
yes, sir.
Close your eyes and throw a dart at the board. You're gonna get it.
No, sir. Yes, sir.
There's a second amendment. Is there
I can tell you,
the unauthorized use of a motor vehicle or evading arrest or detention?
I'm sorry. The cases that he had played, he got charged in Travis County, and I put in the plea paperwork to run concurrent. The possession was one case, right?
Hold on, I don't see one of those.
Your Honor, I was
Yeah.
charged,
Well, I'm sorry, go ahead.
I was charged with the deadly conduct, the unlawful possession of the firearm, unlawful possession of body armor, and collision involving injury.
Right, Judge, and he pled to those.
Wait, okay, hold on. That is an event out of October of 2024.
Yes, sir. And he pled.
Okay, the second amended that we're here on includes two events on December 3rd of 2024 out of Travis County, namely unauthorized use of a motor vehicle and of evading arrest or detention with a motor vehicle.
Your Honor, those were dismissed.
They were?
Yes, Your Honor.
And Judge, what I was asking is that on those four cases that we did plead and got time in Travis County would be the same violations that we was pleading to today.
Which are again, what?
So,
It only needs one,
or just whichever,
right?
One you want to.
You state, what do y'all?
6 and 7 are two of the ones that he pled to, the collision involving serious bodily injury and the deadly conduct discharging the firearm. We'll just plead those two.
That's fine.
Okay, 6 and 7?
Yes, sir.
Yes, sir.
That's fine.
All right, again, did I swear you in already?
Yes, Your Honor.
Okay.
you did.
Things are happening right and left here. In summary, allegation number 6 out of the second amended motion to revoke probation, which is filed on December 30th of 2024. And you were gone for a while because you were disposing of cases in Travis County, correct?
Yes, Your Honor.
And when did you come back to Beaumont?
So I've signed for 4 years TDC.
When did you get back into?
I got bench warranted on the 17th of this month.
Okay, so
Yeah.
okay, there you go. Welcome. Allegation number 6 of this second amended motion to revoke probation alleges that you committed the offense of collision involving serious injury on or about October 27th, 2024 in Travis County, Texas, in violation of condition 1 of your probation order. Is that true?
Yes, Your Honor.
Number 7 alleges that you committed the offense of deadly conduct discharge of a firearm on or about October 27th, 2024 in Travis County, Texas. And that is also a violation of condition 1 of your probation order, which is don't commit a crime in this state or any other state or the United States. And is that true and correct?
Yes, Your Honor.
Are you pleading true and correct to 6 and 7 voluntarily and because those allegations are true as they are alleged?
Yes, Your Honor.
Do you understand that a knowing and voluntarily made plea of true to 1 or more violations of probation, that's enough to grant a motion to revoke probation?
Yes,
Your probation in this case can be revoked and you can be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, Your Honor, I do.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. I see an agreement that you would be your probation would be revoked. You would be sentenced to 5 years in prison in this case to run concurrently with other cases.
Yes, Your Honor.
Is that your understanding of the plan?
Yes, Your Honor.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, Your Honor. I do.
Show you what's marked as State's Exhibit 1 here.
Your Honor.
Did you sign this, understand it, discuss it with your attorney? Are the contents also incorrect?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence
Okay.
without objection admitted. What were you going to say?
I was just gonna say, may I add a few things?
Okay, okay, go ahead, give it your best
I
shot.
just wanted to say, since I got incarcerated, I know on paper it looks bad, but I have gotten my GED. I have done a 10-week drug program. I did a 10-week battery intervention program. This is on the county. After I graduated from those programs, I continued to help people with peer support specialists, helping people with reentry and stuff like that. And since I got into TDC, I've enrolled myself and completed changes.
Yeah. Okay, so why weren't you doing all these good works earlier?
Man, my dad passed away, and then drug use, there's not really an excuse. I made the wrong choice. That's
Okay,
what it is.
yeah, well, we all make bad choices. It's
Yes.
how you fix them
Yeah.
and deal with them. That's the test. And your father's gonna pass away.
Yeah.
Mine did. Yeah, and I'm sure I think about it every day,
Sure.
but you move forward.
Yeah.
The question is, would your dad be proud of you or not? Maybe he's proud of you now. Fixing this, trying to fix it, right?
Getting
Well,
it over with.
Well, you live in their memory.
Yeah.
That's the way to deal with that, I think, because when the creator decides to take away someone, there's not much you're going to be able to stop.
Yeah.
So it's natural, but you work with it. And that does not mean that you then start making mistakes intentionally when you know better.
Yes, sure.
Okay, but you understand that. It's all this.
I apologize.
Be the best you can be. Do good things. I'm going to follow this agreement and find that you have pleaded true to allegations 6 and 7 of this second amended motion to revoke probation. You've done this voluntarily, knowingly, intelligently. That is enough to grant this second amended motion to revoke probation by preponderance of the evidence or greater. The motion is granted and your probation is hereby revoked. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case, and this sentence shall run concurrently with any other sentence. Do you understand what has happened today?
Yes, sure.
Anything else to add? It's okay. Good luck. Do well.
Yes, sir. Good luck for that.
Let me see. Let me see that. Okay, thanks. All right, James Robert.
Yes, sir.
Is that it? You're next. Okay, come on. Right. There he is. Showed up. There are 2 cases here called 25 CR 501 and 25 CR 502. Evading arrest or detention with a motor vehicle and unlawful possession of a firearm by a felon. We're going to swear you in so we can take care of these cases. We're going to dispose of both of these for you.
Yes, sir.
Should have a dismissal on 502, Judge.
502 is to be dismissed, right?
Correct, Judge.
Yeah, put that aside.
First, right hand, square or front, have the proof, the whole proof, and nothing but the proof, so you got. Okay, open your right on front. Right on top.
Okay.
Can you get that one more time?
Um,
And one? That's right. Okay.
I hate to do honors, but
Here, bro.
I got a problem here. I'm showing 3 cases?
Two. That's all it's on the docket is 2. Evading arrest, motivated for possession of firearm or felon.
James Roberts.
The 05.
I have 501 and 502. That's it. Mark through those. Get those out of there. That's what we have. 501 and 502. You are James Lee Robertson Jr.
Yes, sir.
And you were here with Mr. Adams, your attorney, and the state's attorney does. The defendant waived formal readings of the indictments and arraignments here. And we proceed in summary.
Yes, sir.
So I see there's a Reginald Robinson under James. Where's James's other case? What are the odds of that, huh? Yeah, I don't only have one James Robertson here, and I have Reginald Robinson, 1933166 underneath him, but I don't have James's other case 502. Was that going to be dismissed? Okay,
Oh, here, Judge. All right, it looked like it was in your queue, but it was not. It should be in.
all right. And 501. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about September 4th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you are charged with here, sir?
Yes, sir.
This is a 3rd-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. I understand.
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 5 years in prison to run concurrently with another case or other cases, and 25 CR 502. This other case will be dismissed. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Sir.
How do you plead to this, guilty or not guilty?
Yeah.
Are you pleading guilty voluntarily in 25 CR 501 and because you are guilty?
Yes, sir.
I'm going to show you here what's marked. That states Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct? Yes.
Yes, sir.
States Exhibit 1 tendered into evidence.
No objection.
Without objections to vote. Among other things, the states you mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1. It's made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
And you are entering your plea of guilty today, again, voluntarily and knowingly and intelligently.
Yes, sir.
There's nothing further. I'm going to find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. you were guilty of this crime and any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Do you understand what has happened today, sir?
Yes, sir. We asked on what she was saying. The daytime, whatever time that she got in the system.
Two things happen. Unless I order it to run consecutively by law, it always runs concurrent. I don't even have to say it. It runs concurrent with other cases. Also, you are entitled by law to get all time you have served credited toward your service that you have served in connection with this case.
Yes, sir.
I know people worry about it. I would too, but you get that. It's done. It's part of the law. And some of this, I don't even have to say, but sometimes I do it just because people get worried about it, but it runs concurrent. Unless I order it to run consecutive. That's where the law's built. That's so judges don't have to say that every time. I think. And then it gets a gotcha later. We don't want that. All right, I've just dismissed that other case.
All right, thank you, Judge. Thank you.
Yes, sir. Do better.
Yes, sir.
You can do it.
Yes, sir. Thank you.
Where's this?
With the Gertz is here. I know you were looking for him.
Gavin Bond. What are we gonna do? Okay. So on that, that's two. That's two. No, you got 3 cases? All right. Okay. All right. On, he's up here on Powell, Pauletta Powell. We ready on that?
Just, we just
That
need to
says
talk
a
to
plea.
them about it.
Is that a plea?
No.
Well, that's what this, oh, yeah, I see it. No, it says jury trial.
Well, it's
Back in March
gone back
to July 28th.
it's gone back to court, Judge. So this is a case where
Why are we whispering? So you said that.
have it. I get it here. I just talk quiet around it.
This case is set on for a plea hearing. 629. Okay, that's 1472. That's, but the other one will say July. No, that's, sorry, July 28th, 25. That's a frightening thing. Well, I don't have a good docket on this new one. All right, what we're gonna do today.
So this is a case where there's 2 different incidents. Dr. Capon has evaluated her contemporaneous to or close to the time of those incidents and found her to be insane at the time of the offenses. What
are we doing today? That's all.
Well, what we're trying to figure out is how we go through the process of an agreed not guilty by reason of insanity that will allow the court to continue or keep supervision over her, but will dispose of both cases. And so there's some mechanics we have to go through to do that. And we're not 100% clear on what those mechanics look like, but that's what we're trying to present to the court.
I don't even know what authority I have under that.
Well,
okay, so I supervise it. Let's say she fails on supervision. Then what's my remedy?
Well,
I don't have a remedy.
You put her in inpatient. You would have a remedy, Judge. It'd be to put her in inpatient.
Oh, you're going to leave her out on an outpatient program?
Yes, yes, Judge. And Judge, she's been.
Okay, you don't have anything ready today.
We do not.
Well, then, yeah, million things to do.
Okay.
Let me know when you're all ready.
Okay, thanks, Judge.
Let's see. Yeah, Bond.
Yes.
Oh, look.
Hey, John.
Yes, sir.
Wes, what do you have? Here, I've got Elijah Bill. What else?
Elijah Bill's gonna be just a status check. I have one to sleep ready.
And then some other things we need to put on hearing dates. So might be quick when you get to me,
Oh,
except for the plea. There's one plea.
okay.
Mike, let me know what's found out.
It's
Gavin Bond, right? Bond,
Yes,
I need 3 cases of this. Oh. Guilty.
Yes.
Oh, the motions to revoke probation?
Two resignations.
For this.
Motion.
You was asking for laws, 2 nations, your own.
Chapter. You judge has to agree that this is what you're doing, you have to show objections, but. Put it that way, I think that's where it is.
We'll take the numerical, okay, beginning with 25 CR 937.
It's just the best solution.
And you are Gavin Gray Bond
Yes, sir.
with Mr. Kindler, your attorney and the state's attorney. In this 937 case, as well as 938, in each of those 2 cases on November 3rd of last year, you were placed on 5 years deferred or unadjudicated probation for credit card or debit card abuse, a state jail felony in 937, and looks like theft, a state jail felony in 938. Is that your understanding?
Yes, sir.
Okay. And each of these motions similarly allege that you, allegation 1, which looks like the most serious, anytime there's a crime alleged, it's serious, right? It says you committed the offense of assault, family violence by impeding the circulation of choking someone, a family member, under the law. I'm sorry.
This is Brian.
It says the indictment here in 26 CR 49, which is, I believe, the follow-up charging instrument on April 1st of 2026 of those 2 allegations. States you intentionally, knowingly, or recklessly caused bodily injury to Alden Bond, a member of your family, household, or a person with you whom you had a dating relationship by striking Alden Bond in the face with your hands, and that you intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood by applying pressure to the throat or neck by blocking is it Alden or Aiden? Aiden, I think that's an AI. Aiden Brown's nose or mouth with your hands. Okay, that's choking. So that's what is alleged as a violation 1 of this motion to revoke probation, this 3rd-degree felony that was indicted on or about April 1st of 2026. And that 3rd-degree felony carries with it up to 10 years in prison. Then allegation 2 states you failed to provide verification of performing community service hours. 3, you failed to provide verification of completing the theft prevention class. And then 4, you failed to pay court assessed fees as directed. And 5, you failed to obtain a drug patch immediately upon release as directed on your deferred or unadjudicated probation order. Those are the allegations in that motion to revoke probation.
We're just requesting.
There's a motion to revoke probation actually in 2 of the cases, and then this 3rd case is the new case. When was he released from custody? Before.
When we released.
Does anybody know?
Got placed on probation.
Right.
October 31st.
Then you know what you're being,
2025.
or 25.
So.
It's
I
great.
know, I'm talking about when you were placed on probation in the two cases, the credit card and the theft.
Yes, sir. I remember I came to this court on October 31st. I got probation out and I left that same day.
This says November 3rd, 2025, you were placed on probation. Your memory is not
I know that
very good because
That's whatever you remember.
I remember I came here on the 31st from Chargers.
no. And you were released when?
I was released the same day.
That's his recollection, you know.
All right. Well, this states on November 3rd in each of these motions. And that's not right. I'm looking at my probation order was signed on 10/31. This doesn't say on or about. It says on. What are y'all gonna do about that? Anybody?
You're referencing the date that he was placed on
Motion to
probation?
revoke probation state in the motion that on November 3rd, 2025, he was placed on 5 years deferred or unadjudicated probation.
Let me check.
That's not right, because I signed the deferred order on 10/31. I believe I did. Maybe I didn't.
Yeah.
But it's dated that.
That's say 10:30.
It's dated that, yeah.
Judge, I just requested an oral amendment to change it to that, either on or about November 3rd or to the on or about October 31st of 2025.
I'm going to add on or about. Corrected on this day.
Probation expired around happens to be. Minutes ago. Anyone see something happened there?
So it alleges that each of these motions allege the indictment on 26 CR 489 handed up on April 1st
Yeah.
of 2026 as a violation of probation. You failed to provide verification of performing community service hours, failed to provide verification of completing theft prevention class, failed to pay court assessed fees as directed, and failed to obtain a drug patch immediately upon release as directed. And condition 36 must have drug patch on self immediately upon release. And then okay. Did you ever get a drug patch?
No, sir. Okay. I didn't have the money.
He's over 17, right? We enrolled in high school.
I'm sorry, he's old enough to be in this courtroom.
I know, but I think he was still enrolled in high school. So
Nonetheless, it was a court order. And there was a good reason, I guess, because of the issues that were, there was something that must have come up that caused this court to order that.
I don't know if he's been positive on any.
I don't know if they have, no. What are we doing right now?
So I just want a bond, to getting bonds, and then that would give him an opportunity to rectify some of the shortcomings he's had on probation before we come to trial for his position.
Okay, what's they say?
Judge, I wasn't aware about a bond hearing today, so I hadn't reached out to, I know there's a victim in the new case. I hadn't reached out to anyone. I wasn't prepared for a bond hearing today.
I'll represent to the court that the victim, I showed this to an issue that the alleged victim did text me wanting, asking about a bond from one of their brothers. And just, I think, obviously, you know, I have my opinion about the new case because it was a fight between brothers. And I don't know that the alleged victim is necessarily being opposed to the bond because of the context of the text message. The text message I received, Mr. Bob's grandparents are present, Your Honor, for
Were they witnesses to the event? Were you a witness to the event, sir?
He's hard to hear.
No, I was not
Okay.
witness to the dust up of the brothers. Was that the question?
Yes.
No, I was not witness.
Okay.
He's hard to
saw
hear.
the end of it.
Your grandmother saw the end of it, Your Honor.
I saw it and it was, I feel that it's been, it wasn't as significant as stated.
Well, the grand jury thinks otherwise. They're the ones who control. Yeah, sir, you don't wear a shirt like that. Sit outside. We'll call you if we need you. Sit outside. Don't come into court with stuff on your shirt. That's not appropriate. Would you wear that to church? No. This is important too. Gosh, just. She said, what time here?
They allow her to see soul here. Let's keep it about that.
She saw part of it, not, the point is that I'm not working on what she may have seen. I'm gonna work on the problem, what the law says. We've got a probable cause affidavit here, and that's what I'm gonna rely on.
I'm just trying to get a bond today, Your Honor.
I understand.
And he's 17.
What are you asking for?
A low bond so he can get
What, how much? What?
$2 bond.
You may be seated, ma'am.
I think they let her stand there.
You can be seated. Yeah, it's better that way.
Since he's 17, we request a personal recognizance bond, but that's probably, that's below $2,500 age. What?
How long were you released before this happens? According to this? How long?
It was a few months. I think it,
Is that what you're saying?
January. I think that's when he said it happened.
January 3rd, 2 months, 60 days. 60 days. Thanksgiving and Christmas go through, and then here you are back here.
Yes, sir. I just want to say that it's not how he says it is.
I'm sorry, but the grand jury thought otherwise, and right now we're working on what the grand jury decided. So this isn't the debate.
Yes,
but
sir.
we'll certainly have a hearing as soon as possible. But it's a crime of, this is a crime of violence. Choking somebody, you have only one intent when you choke someone. That's to kill somebody. Breathing comes in handy in life. And that's what you're charged with, is putting your hands and strangling somebody. That kills people. Don't minimize the allegation. It's serious. And it's on my watch. I let you out on probation. And 2 months go by, and here you are, accused of choking someone, which is essentially an attempt to kill somebody.
I'd also like the court to take note, and on my file, it says that the defendant failed to appear on May 27th. And so bond was increased because of that. May 27th of this year.
It's not on the jacket.
So I was a little late.
It's not on the jacket.
I don't think it was an FTA. You said he was late, or he went to the other wrong courtroom, was probably called and then recalled.
You're kidding me? You go to the wrong courtroom?
I called the bondsman and he told me to go to Miss West.
Why?
That's who we believe that, the judge is over my case, but.
Well, don't you know who was over your case? Me. You reckon? Do I look like a girl
No, sir.
to you? No, that's.
Yeah.
Judge West doesn't look at things.
Yes, sir.
I have to shave every day. He doesn't. He puts on makeup. I don't. There were two different, completely different looking people. And you made that mistake? Well, you saw her come out. Didn't you see? And that's not the same person as me, as the other judge. I mean, didn't you figure that out?
Well,
Common sense. Do you have it or not? Do you walk out into the highway? Do you walk into the highway, Interstate 10, and just amble about? Do you? Because that's common sense. You don't do that, right? That's an unwise thing to do. That's unwise. Sitting in there, you see her, she's in there doing her business. She looks like me? No. You need another bondsman. They make those mistakes. You wasted some money. What are y'all asking for? State hadn't said the thing about how much it was.
Judge, how much is his sorry, Lacey, can you tell me how much his current bond is on the case?
Yeah.
she said. Yes, sir. Me too.
What happened on the motions too? On the motion, what the bonds on the motions?
On the new case, the bond is set at $10,000.
No, I'm talking about the motions to
Yes,
revoke.
I was answering, Ms. Nail's question, on the MTRPs.
Does he have a bond on the MTR?
No, that's why we're here.
Okay, he doesn't have one yet, right?
Without one.
Okay, he's got two. We have a
I'm checking the other one, but I'm pretty sure it's gonna be the same.
underlying crime of violence. And 2 months later, we've got motions to revoke probation. What was his bond on the, what did you say his bond was on the?
10,000 on the vacation,
On the, it was 10,000 originally on this,
on the new case as well.
on 26,489? The assault,
Yes, sir, 10,000.
It's 10,000.
what state say?
Whatever the court feels is sufficient on those two MTRP cases, Judge, the state will follow along with the court.
Yeah. Actually, sign this report.
He's currently a Westbrook student now, but the court now.
So that doesn't keep him from committing crime.
I mean, it may impact the court's decision on bond conditions as well. I'm saying as far as safety of the community and other states.
Somebody else is gonna end up paying for it. We all know that.
He really doesn't have anybody.
I know, somebody else is gonna end up paying for it. Will the state asking under this?
Whatever the court follows, sets it at judge, the state is okay with that.
Okay, we've got this pending 26,489 that's open because it's on deferred. And then we've got two motions to revoke probation.
.489 isn't on deferred, Judge. It's still pending here. We haven't done anything with that.
Yeah. That's
So.
Yeah, that's the new case. And the two old ones are the motions to revoke probation. All right, it's 25,000 on each case. Plus, can't have any contact with the victim. 25,000 on each case. Plus, you can't have any contact. Plus, you're at home confinement.
How would it meet his
Except to go to and from education To and from your lawyer. To and from food. To and from work.
I guess Mr. Sutter got me to and from Westbrook High School.
I said to.
What
I said
education, but
I
Westbrook.
said school, whatever that is. He's in school.
Judges, he has a GPS device. Or
Yeah, and yeah, have a GPS device so we know where you're on. When you're not at home. Those are the orders. Then what's our next event?
Set it for here. I mean, I'm not gonna contest that administrative.
Yeah.
I'm sure they-
Okay.
can see it.
That's what we're doing. It'll be set for here in the future. That is on. Who's? I had Scott Rennick on something. Aaron Simpson. Where's Aaron Simpson? Is he in custody?
Yes,
Okay, I haven't seen. All right. That's reset. For defense attorney's failure to appear. That's reset for a week. Let's see, John.
Yes, sir.
Well, Elijah, Bill.
Mr. Bill is just outside. He's the one that sent out, saying to go.
Wait, hold on. Let me ask. Brent, what are you doing?
Mr. Robinson.
He's got one more, please.
All right, let me do Robinson real quick now.
Come on.
Thanks.
We need a fingerprinting.
Fingerprinting.
Where or from to tell the people the truth and nothing but the truth, something about. You think up your right number. Place it up there. Ink it up one more time. Is it flowers? Okay, can I see if I'm judged?
Come forward, sir. 19-33166 is called, my God, that's an old case. 19-33166 is called the State of Texas versus Reginald Robinson. That's you?
Yes, sir.
Present with your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about June 30th, 2019, I think I was a teenager then, in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with the use of a motor vehicle. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case, stand by, where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, and shortened to 1/3 if you do well. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Going to show you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into
No objection.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's really involuntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
Anything anybody want to add?
No.
Not, I'm going to find, Mr. Robinson, you are pleading guilty voluntarily. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that the probation officer is going over with you. And this will be for 10 years, but we will shorten it to less than that if you do well, 3 1/3. There will be terms and conditions of probation, which are normal and customary. Make sure you follow those. If you fail, your probation could be revoked. You could then be found guilty and then sentenced up to the full range of punishment, up to 10 years in prison. So you don't want any of that. Oh, one of the conditions of probation, and there are a lot of conditions of probation, but like I said, somebody not long ago, most of these I have to follow.
Yes.
She has to follow. We all have to follow. Like, don't commit a crime. For example, here though, there's another one. You're going to have to take and complete defensive driving. And you go, roll your eyes. Let me tell you, this will be the best thing that happens because your insurance will drop.
Okay, yes.
I mean, and you learn a little bit about driving that reminds you about the good things, but your insurance will drop. And that's what you want. It's something less to pay for per month. All right, please see the probation officer. Thank you. Is that it, Brent?
I think so.
Okay, John. Oh, what are you at? Brent took up all your time.
I know. Losing time.
Like that. All right, I have Elijah Bill.
Mr. Bill, he's right outside. He's on
What's with that?
Elijah Bill.
Is he the guy with the shirt?
Yes, sir.
He didn't borrow that one from you, did he?
No, but I would disagree with you on that. I didn't find anything bad about it. I thought it was a nice button-up shirt. It's just decorative.
It's what it calls attention, and that's,
Well,
you don't want that.
sure, but it's not like a T-shirt or something like that. I would disagree with Lisa.
Come on.
It's
now.
actually a button-up shirt. It's a
All right. You are Elijah Bill.
Yes, sir.
What are we doing?
You know, this is a status check. 3 months
I need
ago,
to-
you continued him on probation, and you just wanted to come back 3 months to see if he was still on track.
Are we? Is he on track?
Yes.
Good.
Yeah.
Very good.
I think we just need to bump it down for another however long the court wants to make sure he stays on track, and all good.
Okay, he's on probation here for 2 years from December of 24. So he's coming up to the end of this, right?
Yeah. December this year, he'll be off.
And he's been doing well.
Yes.
Okay.
Is there a motion pending that we still have, or?
There is a
Yeah,
motion
it's a pending motion.
in February.
Want us just dismiss the motion, dude?
What do y'all want to do?
We can always be filed.
I'm trying to dismiss it. That way we'll just see if.
It's a failing to report, failing to work faithfully, failing to provide verification of community service hours. Has he caught up with all of that? Hold on.
He says he's working at Cam as a flagger.
Is that right?
Yes, sir.
How much do you make an hour?
14.
Sir?
Oh, $14 overtime. is
Okay,
21.
that's 30 grand a year. It's full time?
Yes, sir.
Plus potential overtime too sometimes.
Okay,
Yeah.
what about that's suitable employment? What about failing to report? Is he fixed
Since
that?
I have been on, since he's been on the mental health caseload, he hasn't missed an appointment.
Good, very. And failed to provide verification of performing community service hours. Is he
He
doing?
still has 15 hours remaining.
Oh,
Not bad.
okay. And then this court assessed fees.
He has made a payment since he's been on the mental health
Okay.
caseload.
Well, I don't want to bother him. He's doing fine.
Yeah, interpret dismissal on.
I think
And he's on a class, this is a class A hey guys, this is a class A misdemeanor. It was a lesser included, reduced down. I mean,
Motion to dismiss the MTRP to just send,
okay,
so once it expires, it's done.
Yeah.
And
you say, you're almost finished.
Yes, sir.
The motion to revoke probation is going to be dismissed. There it is, right? There it is right here. So I've got that dismissed.
So,
Okay,
Make her happy.
you got that going for you.
that's one.
Yeah.
Today.
I'm prolonging this so Dennis doesn't leave. I'm gonna stall as long as possible.
Wow.
This could go on for years.
Oh, to keep
This
Dennis
docket,
here?
yeah, this
Yeah, I think we
docket
should
should go on for years.
We're gonna take as much time as we can so Dennis can't leave. We're gonna take all the time we can so you can't leave.
I think he wants to go get a steak.
He's like, if it's 5 times, I don't care. I'm still
Hey, we got him.
He's walking out no matter
We
what.
got him steak dinner for the rest of his life. At that's the Longhorn.
Okay.
Great place right across from the mall. And
I like it.
Yeah. All right. That was Donald Kelly.
No, that was not.
No, that was not
Donald.
Donald. I need Donald Kelly next.
He's the one that's gonna plea. We've already.
Where's Donald?
He's in custody.
In back.
And we've already.
Then Shaquille Maxon.
That is gonna be. He wants an MTRP hearing, so we need to reset for a hearing.
Okay. Where is he? In the back?
In custody. Yeah.
Tito Means.
Your Honor, this was supposed to be on the trial docket. I'm not sure why we're not on the trial docket. I think I'm not sure.
Tito Means.
We don't want it on the docket. I don't make the docket.
I know. I didn't know if you knew something from Ellie or something, but
He's filing a bunch of pro se motions. Did you
maybe
know
that's
that?
what it is. I've talked to him. He's just he wants to get the trial and.
Yeah. Well, does he know we try more than anybody in the country?
I don't think
Does he
anybody
know that?
really cares about that.
He doesn't think.
I understand, but most people don't really understand.
Well, I
that.
mean, I regret I have but one body to give in my county.
Trust me, Judge. I know. I've been here quite a bit too. I understand, but not everybody in jail understands that. But
Okay.
yeah, we set
You
restraint.
are
On Kelly.
Mr. Kelly.
Yes, sir.
And 26 CR 702 is called. This is the manufacturing and delivery of controlled substances. He pleaded guilty. Defendant pled on 226 in a case. This one, I guess, was still pending.
Right.
We need to fix this, right?
This was filed after the one we tried, but it was from before
We tried
that.
it.
Yeah, we tried. So
Okay, so you are Donald Kelly
yes, sir.
here with your attorney, Mr. West, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in such?
Yes, Your Honor, please.
We're only going on paragraph 1. There's
I
a
believe
enhancement, but
they get it.
you're showing second degree felony
Yeah, we're just going.
without the enhancement.
Do we need an enhancement?
No.
I don't think we need it.
Is that what we're going to do?
Yes, sir.
Okay. In summary, Mr. Kelly, this indictment alleges that on or about February 9th, 2025 in Jefferson County, Texas, you committed the second degree felony of manufacturing or delivery of a controlled substance, namely cocaine. Do you understand what you're charged with here, sir?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000 for this second degree felony. An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison to run concurrently with other cases. Is that your understanding? It runs the same with another case. 24 CR 581.
No. You means the other case you got probation on. This new probation is going to run right with it. They're going to be together. Yes, sir. Okay.
It's not, and you would be sentenced to 10 years in prison. That would be suspended in this case, and you would be placed on regular probation for 10 years.
Yes, sir.
You would be convicted, but you would be on probation. If you failed your probation could be revoked, and then you could be sentenced up to 10 years in prison if that happened. So you got to do well on probation.
Yes, sir.
Is that your plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit is made a part of the record for all purposes. Pre-sentence report is waived here.
Yes, please.
I will follow this agreement. If nothing further and find you are pleading guilty voluntarily, you're mentally competent to do so, you understand and appreciate the consequences of pleading guilty. There's enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second-degree felony of illegally possessing with intent to deliver cocaine. I am following this agreement. You are hereby sentenced to confinement in prison for 10 years. That is suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, and make sure you follow them. If you fail, your probation can be revoked.
Yes,
You
sir.
can be found guilty and sentenced up to 10 years in prison. This sentence, by the way, shall run concurrently along with that other case that you have, 24 CR 581. I don't know, are you on probation on something else?
There's a case we tried to already got probation after trial, and he's on probation from that
Okay.
already.
These two sentences shall run at the same time,
Yes, sir.
but do well.
Yes, sir.
You don't,
Yes, sir.
hold on. What's DOEP? I can't even pronounce that. Dope?
Drug offender
Dope?
education
Program.
program.
Okay. Sorry.
What is it?
Drug offender education program.
It's a new one to me. On that, y'all never used those initials before that I can recall.
That's a good name for it. Dope.
I feel like a, what am I gonna say? We should send a memo or something so I can keep up with this. All right, I've signed these. You're on probation. Good luck.
Thank you, Your Honor.
Get,
Yeah, I gotta go
some print on
You'll be back here. You did this out in the bar. What happened?
We're getting toward the end.
the.
Getting excited.
A guy did it.
Dennis is gonna go get a steak.
For you to do it
We can
to
just get him out of here.
get it flat. He's gonna think, yeah, I know it's gonna be.
Your Honor, I had
You need it
more
flat right now.
Watson. The underlying offenses for the probation. One of them is a drug case, and the state does not have the drug
Thank
test.
you.
You got two of them. I got a Shaquille Maxon.
Oh,
Hard time getting it
that
flat.
one's gonna be, no problem.
Corner.
Oh, yeah.
What are we doing on Shaquille?
It's right there.
I think that one's ready to be a hearing. So it needs time to
Thank you.
get
Yeah.
it on there, get witnesses and ready.
Mr. Woods. He's on board with the first.
Okay, I have Shaquille Maxon. What do you want to do on that?
Your Honor, that, we want a, NTRP hearing, there's a new offense, I think state will need to approve of.
All right.
However they need.
Lawyers, that's going to be Miss Gasper. So I guess somebody's going to help her on that one, or
Yes, sir.
are you Miss Gasper now?
I am not.
All right. Somebody is going to be, right? She's moved on to,
Other
okay.
things.
There's a motion to revoke probation. They want a hearing on this.
We'll figure it out, Judge.
Yes.
And it's, yep, let's fleeing and intoxicated,
Yeah.
intoxicated. Let's get this hearing quickly.
Simple enough, Judge.
I know, what do y'all think? About 3 weeks, good?
2 to 3 weeks.
All right, set it for 3 weeks, okay? Thank you. Elijah Watson?
Your Honor, that one, I believe, Mr. Larry can correct me if I'm wrong, but they're waiting for drug tests for the underlying offenses that are the basis of this revocation. So I think it needs some time. Mike? That's perfect. Okay. Sure.
Well, once again, this is an NTRP as well.
New offenses, yeah.
And there's a license the offensive license required. What does that
I'm
mean?
not sure what that is.
What does that mean? What does license required mean? That's the allegation of violation
I have no idea.
on Elijah Watson.
That's gonna be.
But I'm gonna prove it in 3 or 4 weeks.
I don't know if you are.
Yeah, same type of reason.
Oh, first test, I got away from about 4.
I'm not sure.
You just watch me.
I'm not sure that one
Yeah.
is going to pass.
I don't know if it's a parson's license required or what, no. But I'm gonna prove it, you just watch me.
You know what? Yeah, yeah.
You know
I'm not sure
what?
about the other one.
Let me say the administrative violation states from, wow, I signed it too. The administrative hearing memo states condition 1, committed the offense of license required. I don't know what that means. I've never seen that ever.
You're gonna love this. It's gonna be great. When we put the proof on, you're gonna love it.
It's
They figure out what they're talking about.
Let's earmark this. This is gonna be great.
This is gonna be so great.
We might both get involved there.
We're gonna make the license required great again.
All right.
I don't know. Nobody has any idea.
What y'all obviously don't know is that this is operating a motor vehicle without a license, which needs to be obviously, that allegation needs to be tinkered with a little bit. So that could, please note, license required, I don't think is good enough on that one. And that needs, and then possession of controlled substance also. And I'm sure it's illegal possession of controlled substances.
That's what they're waiting for the drug test to come back on.
Okay, how much time?
I'm gonna-
3 weeks too. We're gonna do 3 weeks as well on this one, folks. Okay, on Elijah Watson, thank you.
I believe that's all of mine that I asked.
Yeah, man, sometimes you probably something go to work, but then some of the stuff on there, and I keep finding it. Sure, that somewhere. Reading to reach myself some. Figured it.
Okay. Cameron Koger, what did I do that? Okay, I didn't check it off properly.
Okay, I think all we have Keto Means left.
Is who?
Keto Means.
Keto means.
Anything other than what to do.
That's it. 24 CR 1522, John West.
That needs to
be put back over.
I think you're crazy. But even if you're right, I still think you're certain have. But yeah, it's in all, okay, but it's in the court file, if you look at it on the record.
I think he's been filing pro se paperwork. We probably need to bring him out.
John,
to see if he should be
on
represented.
keto means.
That should be on the trial document. I thought we were
Set for the trial document.
Hey, there's a note here that.
He
says
keeps
that
filing a
filed
bunch of-
Pro se motions. Do we need to bring him out? Pro se or?
You need to
Represented?
work with him on
I
that.
talked to him earlier and
He still wants you to represent him, huh?
he gave me some motions he wanted me to file for him. Some of them I'm not going to file because they're not
Well,
correct.
but unless they go through you, I'm not gonna,
I know. He gave me the motions he wants to file. None
we're
of
not
them.
gonna have them
I think he
represent.
said it to see if he wanted to be pro se or represented.
He's fine. I'll talk to him about
That's
it.
good enough for me.
Yeah. So
All right,
if he
anything
changes his
else?
mind, I'll let you know.
We're in recess. Hey. Happy 4th of July.
The hearing began with a defendant facing an extremely serious charge: possession with intent to deliver cocaine, a second-degree felony carrying a possible prison sentence of 2 to 20 years and a fine of up to $10,000. Before accepting any plea, the judge carefully explained the punishment range and made sure the defendant understood exactly what was at stake. A plea agreement had already been negotiated between the prosecution and the defense. Under that agreement, the defendant would receive a 10-year prison sentence, but instead of being sent directly to prison, the sentence would be suspended, allowing him to serve 10 years on probation. The judge emphasized that this was a major opportunity, not a guarantee. If the defendant successfully completed probation, he could avoid serving the prison sentence. But if he violated even one major condition of probation, the court could revoke that probation and require him to serve the full 10 years behind bars. After confirming he understood every consequence, the judge asked whether he was pleading guilty voluntarily and because he was actually guilty. The defendant answered yes. He also confirmed that he had reviewed and signed the written plea paperwork with his attorney, understood every constitutional right he was giving up, was mentally competent, and was fully satisfied with his lawyer's representation. With those answers on the record, the judge formally accepted the guilty plea. He found that the defendant was mentally competent, understood the consequences of pleading guilty, and had entered the plea knowingly and voluntarily.